Günther, and special thanks to Anne and Joshua, who are joining us from Jerusalem and London, respectively. I'm in Bloomington, where it's cold and snowy today. Wherever you are, I hope you remain well. Steer clear of the COVID bugs, if at all possible, and thrive in every way you can. Anti-Semitism received some exclamation points in recent days because of the news of it certainly had, because of what we learned about the incident at the synagogue in Texas. But as we all know, that was not the first incident of its kind. We all wish it would be the last, but realistically speaking, that's unlikely to be the case. So we're living at a time certainly of heightened anti-Semitism. The Texas incident, like the Pittsburgh, Poway, and other incidents, manifest themselves in especially violent ways. But in other respects, too, anti-Semitism is an ongoing issue for any thoughtful person today. And much of it, in fact, is directed not just at Jews, but at the Jewish state itself in ways that go well beyond legitimate criticism of this policy or that leader or a particular action, to condemnation and demonization of the state itself. The language of that discourse is going to be part of the concern of our speakers today, in as much as they're going to take us through the history and present development of the apartheid charge, which has branded Israel a new South Africa. South Africa under apartheid lost its legitimacy and should have, and there's an attempt to do the same to Israel today. Substantively, you'll learn lots, and as Günther said, there will be a chance to engage our speakers in conversation about these matters right after they finish up. Just very briefly, a word or two about them. Anne Herzberg is the legal advisor of NGO Monitor. She works closely with Gerald Steinberg and others there. They've both been to conferences at Indiana University. So Anne, a special welcome once again to you. Next time, I hope face-to-face in Jerusalem. Joshua is a new face for our program, and we certainly welcome him. He's a barrister at 9 Bedford Road Chambers in London. His the concentration of his work in particular involves the practice of criminal law, particularly international human rights law and international criminal law. It's now my pleasure to hand over to the two of you. Thanks once again for joining us.
Thanks so much for having us. We're really honored to be here to speak with everyone. I'm going to start things off by speaking about the discourse and history of the apartheid charge as levied against Israel, while my colleague Joshua Kern will focus on how this charge has been instrumentalized legally to delegitimize Israel's character as a Jewish state. And our remarks are based in part on our December 2021 reports. And if Günther, if you could show the first slide, it just shows the cover of our report. And I will post the link in the chat. We're going to be issuing a companion report in the next few weeks addressing how the apartheid charge relates to specific policies in the Arab-Israeli conflict. And our hope is, and our research is ongoing, so our hope is to turn these reports into a book that we'd like to publish in early 2023. So in April 2021, Human Rights Watch issued a publication entitled "A Threshold Crossed: Israeli Authorities and the Crimes of Apartheid and Persecution." And this had followed a January report by the Israeli NGO B'Tselem declaring a regime of Jewish supremacy from the river to the sea. And if Günther, if you could just go to the next slide if possible, just showing those reports. They got extensive media coverage, particularly in elite outlets such as the BBC, the New York Times, and the AP. And the PR campaign promoting these reports emphasized that this was a notable moment where the charge of apartheid, previously confined to Palestinian civil society and ideological fringes, had for the first time gone mainstream. So in that narrative, Israel's mendacity had reached such a level that the leading global human rights NGO and Israel's premier human rights NGO, who had supposedly refrained from using this characterization before, could no longer remain silent. Now, the media spin aside, this charge was neither new, nor were these reports even the first time that these organizations had invoked it. The coverage also ignored the anti-Semitic underpinnings of the claim. The renewed levying of the apartheid charge was clearly timed to take advantage of recent developments at the International Criminal Court and the UN. So in December 2019, the ICC prosecutor applied to the ICC pretrial chamber for confirmation of jurisdiction to open an investigation in the situation of Palestine and to examine alleged violations by Israel in the West Bank, Gaza, and East Jerusalem. And her request was granted in a 2-to-1 decision just about a year ago in February 2021. In addition to that, the Palestinians filed an interstate complaint at the Committee on the Elimination for Racial Discrimination in 2018, the first time that procedure was invoked, alleging apartheid. And this represented the Palestinian strategy of using their non-member state observer status at the UN to internationalize the conflict. In an unusual move, the CERD committee agreed in late April 2021 to assert jurisdiction over that complaint, despite the opposition of the UN's Office for Legal Counsel. And the committee is expected to begin its deliberations sometime this year. Coupled with all of this, at the end of May 2021, following a month of conflict, the UN Human Rights Council established an unprecedented permanent commission of inquiry to investigate not only alleged violations of humanitarian and human rights law stemming from the events in April and May 2021, but also all underlying, quote, root causes of the conflict, including, quote, systemic discrimination and repression based on national, ethnic, racial, and religious identity. And the terms of reference say that the commission is to, quote, seek to identify overall patterns, policies, historical legacies, and structural inequalities, and will coordinate with other existing UN mechanisms. So to that end, the UN Special Rapporteur for the Palestinians, Michael Link, is currently drafting a report to claim Israel is committing apartheid that he will present to the Human Rights Council in March. And the COI will issue the first of its 2 reports, one to the Human Rights Council and one to the General Assembly, in late June or early July of this year. So in other words, in 2022, there will likely be 3 reports issued by the UN, coupled with possible resolutions proclaiming Israel to be apartheid. In essence, we are on the cusp of another 3379 moment. Given these upcoming events and the prominence that will be given to the apartheid claim as a result, it is important to examine the history and ideological underpinnings of it and substantially measure such charges against the legal definitions. And for these reasons, Josh and I decided last spring to collaborate on this issue. So the term apartheid is a legal term stemming from the policies and practices in Southern Africa that ended in the early 1990s. And this term has been instrumentalized in order to denigrate Zionism and to attack Israel's legitimacy. The apartheid charge began in the late 1950s, early 1960s, though many of the ideological underpinnings were circulating for many decades prior. It represents a fusion of both old and new anti-Semitism. And to orient ourselves normatively, we should turn to the International Holocaust Remembrance Association working definition of anti-Semitism, which says the following, that making mendacious, dehumanizing, demonizing, or stereotypical allegations about Jews as such, or the power of Jews as a collective, or the myth about a world Jewish conspiracy, or of Jews controlling the media, economy, government, or other societal institutions are forms of anti-Semitism. But most importantly for our purposes, the definition also includes the example that denying the Jewish people their right to self-determination, for example, by claiming that the existence of a state of Israel is a racist endeavor, is also a form of anti-Semitism. And if we turn to the next slide, in 2021, the European Commission issued a handbook that went into a little bit more detail explaining that example. And they wrote that denying the Jewish people the right to self-determination and a national homeland is anti-Semitic because it denies the religious and historical ties of Jews to the land of Israel. It evades the fact that the state of Israel was founded in 1948 based on Resolution 181 of the General Assembly. Moreover, asserting that a country is a racist endeavor by portraying ambivalent aspects of modern statehood in a demonizing manner exclusive to the state of Israel is an attempt to undermine the international legitimacy of a country. So the apartheid accusation is really a more extreme version of the Zionism is racism charge. The UN, unfortunately, has been the primary venue for this attack, and its influence cannot be underestimated. So official UN organs, UN agencies, and independent experts who have used their UN appointments to promote their personal political agendas have all extensively advanced this charge. It was originally used in UN fora by the Arab delegates, and later it was used by UN officials and human rights NGOs participating in UN events. As noted by one former UN rapporteur, the UN role is critical. In his words, the production of UN reports, quotes, normalizes the use of apartheid in relation to Israel. It also gives confidence to church and labor groups that might previously have been hesitant to go too far out on a limb in their criticisms, end quote. The charge is powerful because it is an easy way to essentialize and exploit anti-Semitic tropes to transform the conflict from one of disputed land and Arab rejection of Jewish presence in the Middle East to one of Jewish racism. And today, as we are unfortunately very familiar, racism is one of the worst accusations that one can be charged with. And of course, South African apartheid is one of the worst human rights crimes of the 20th century. Another powerful aspect of the allegation is that it has a plan of action built into it, namely boycotts, international isolation, and ultimately elimination. Those levying this charge understand the strategic value very clearly. As former UN official John Dugard and Irish academic John Reynolds wrote in 2013, apartheid is a loaded term saturated with history and emotion. It instantly conjures up images and memories of discrimination, oppression, and brutality, indulgence, privilege, and pretension, racism, resistance, and ultimately emancipation. The conference report from a 2013 legal conference with the PLO, UN, and NGO officials noted that the charge resonates negatively worldwide and can serve to mobilize public opinion and political support. A 1995 article in the Journal for Palestine Studies advocated shifting from an occupied territories paradigm to an apartheid paradigm as a way for anti-racist intellectuals, especially in the US, to analyze the Arab-Jewish conflict in Palestine. Nora Arakat from Rutgers and Reynolds in April 2021, however, cautioned activists against using law-based advocacy because it fixates on Israel's excesses and not Zionism's essence. But leveling the charge in legal frameworks can work in tactical service of broader anti-apartheid political strategy and grassroots organizing. Now, there should make no doubts that the political objective of those who levy this charge is to advance a one-state solution. As a prominent legal academic who was hired by the UN to write a report on Israeli apartheid, said that examination of the doctrine of sustaining Israel as a Jewish state is essential to resolving the Palestine problem. By finding Israel to be an apartheid regime, the two-state solution is exposed as legally fallacious. Apartheid is not ended by moving a border. Forms of the charge include the following. So it can be that Zionism stands alongside apartheid as one of the great 20th century evils, including racism, Nazism, and colonialism, that Zionism is apartheid itself, that Israel is engaging in apartheid practices throughout territory under its control, that Israel cooperated with the South African apartheid regime, that Israel is worse than the apartheid regime. And I've even seen apologetics for apartheid South Africa. One former UN official noted, for instance, that the apartheid regime was more honest and that there was actually a positive element of apartheid in contrast to Israel's treatment of the Palestinians. Even following the 1967 war, the apartheid charge remained focused on the essence of Zionism and Israel's Jewish identity, and Josh will be speaking more about that in his remarks. The rhetoric is based on longstanding anti-Semitic tropes taken from the protocols, Nazi, Arab, and Soviet propaganda. And these tropes include that Judaism is a religion of racial supremacy and exclusivity based on the claim of being a chosen people, which has been incorporated into Zionism as a central feature. Jewish supremacy was a terminology utilized by the Nazis, but also popularized in the US by Henry Ford in the 1920s. Zionists invented the concept of Jews as a people to usurp Palestinian and Arab lands, that the colonial powers in the UN were manipulated by the Zionists into the partition plan and admitting Israel as a UN member state. Zionism has not been raised for review in any international diplomatic process, that UN and UN officials would like to brand Israel as apartheid and impose a South African-like policy, but the institution is too weak to resist cynical geopolitical manipulations. The Afrikaners were honest about their motivations, while Israel and Zionists are deceptive and sneaky about them. The Palestinian ability to leverage international law has been hampered because, quote, and this is from another UN official, Zionist influence over the public discourse and media treatment and exertion of backroom influence. And Palestinian nationalism, this was again from someone who wrote a report for the UN, Palestinian nationalism has the advantage of being consistent with international law, which Jewish statehood in requiring apartheid to survive is not. So precursors to this accusation can be seen in statements made by the representatives of the Arab Higher Committee and the Arab League during the various commissions on the Palestine question, and in UN debates shortly before and after Israel's founding. And I would encourage everyone to read a new book out by Steven Zipperstein from UCLA about Zionism and Palestinian nationalism, which includes several examples of this. But the really explicit invocation of the analogy can be seen during the early 1960s at UN debates, primarily by the Arab states, but it became more widespread as a result of the Cold War and the increasing denigration of Zionism pushed in Soviet propaganda. And it was further popularized as a part of decolonization and regularly featured at meetings for the Organization of African Unity and the Non-Aligned Movement. An interesting figure, and if you could show the next slide, is a man named Fayez Sayegh, who was a Syrian-born academic and a notable figure in the Syrian Social Nationalist Party, and later became the founder of the PLO Research Center in Beirut. And he also actually represented Kuwait at the UN in the 1970s and was responsible for drafting Resolution 3379. So it's you can see in the slide, this is a sample of his writings equating Zionism to apartheid. And if you look at the next slide, there's an example of some of the rhetoric that was used by Arab states. This one was taken from a 1968 Security Council debate. And also you can see the invocation of anti-Semitic tropes. The Israeli delegate to the UN is referred to as a banker. Hitler is referenced. So you can see the intersection of all of these tropes. And GA resolutions in the 1970s really began incorporating the apartheid analogy. So Resolution 3151 from 1973 condemned the unholy alliance between South African racism and Zionism. The 1975 Women's Conference called that peace requires the elimination of colonialism, neocolonialism, foreign occupation, Zionism, apartheid, and racial discrimination. The Organization of African Unity's 1975 resolution stated that the racist regime in occupied Palestine and the racist regimes in Zimbabwe and South Africa have a common imperialist origin, forming a whole and having the same racist structure. Resolution 3379, declaring Zionism as racism, explicitly references and quotes these resolutions. It was promoted by academia in the 70s and 80s, using the same language and themes. In the 1990s, there was a bit of a waning in the use of this analogy, primarily because Resolution 3379 was repealed in 1991, and it was further suppressed by geopolitical events such as the end of the Cold War, the end of apartheid in South Africa, and the peace process and the Oslo Accords. In 2001, however, the charge was revived at the Durban conference, the UN Durban conference. And most of you are probably familiar with the basic details of the conference, but I just want to mention a few key points that apartheid was really a central feature of the conference documents. And we should be reminded that Jews and Israelis were blocked from participating in the preparatory conference in Tehran, where a lot of this language was adopted and put into the draft declaration. And if you can go to the next slide, this shows some of the draft language that was included. And this draft language was only taken out of the main document and toned down as part of a last-minute deal between the High Commissioner Mary Robinson and the EU to avoid a larger walkout from the conference. But instead, that language was migrated into the NGO Forum Declaration, which if you go to the next slide, you can see. And what's notable about the NGO Forum Declaration is this explicitly launches the campaign to apply a South African model towards Israel and was the beginning of the BDS campaign. So it began at the 2001 Durban conference. Now, fast forward a few years, and we see that there are two UN rapporteurs who really take the charge to the next level. Their names are John Dugard and Richard Falk. John Dugard is a South African academic who wrote about the legal aspects of apartheid and parlayed this prominence into several notable roles at the UN. And in 2001, he became the special rapporteur for the Palestinians. In 2007, he presented a report to the Human Rights Council, noting that the international community had identified three regimes as inimical to human rights: colonialism, apartheid, and foreign occupation. And he said that Israel is the only, quote, Western affiliated regime that denies self-determination and human rights to a developing people. And he called on the International Court of Justice and others to study the legal consequences of a regime of prolonged occupation with features of colonialism and apartheid. And his call was taken up by the Human Sciences Research Council of South Africa, and he assisted them in putting out a report in May 2009, along with several figures who are even today very active in the apartheid charge. And this report had a huge influence on the discourse going forward. And in fact, HRW's 2021 publication is basically just a repackaging of this report. It didn't really break any new ground. Following his tenure as rapporteur, Dugard was a very prolific writer on this topic. He appeared at, for instance, the BDS Russell Tribunal, which included notable traffickers of anti-Semitic conspiracy theories, Alice Walker, Cynthia McKinney, and Roger Waters, among others. His 2011 submission to the Russell Tribunal opened with a paragraph admonishing Jews, where he writes that he wishes to begin by commenting on a matter that saddens him deeply. During the apartheid years, South African Jews played a disproportionate role in the liberation struggle. Today, South African Jews are so divided on the subject of Palestine, and many who fearlessly and courageously opposed apartheid are unwilling to face the reality of Israel's policies and practices. And later in that submission, he actually went on to engage in apologetics for South African apartheid, where he wrote that there was a positive element to the apartheid regime, albeit motivated by the ideology of separate development. It established industries in the Bantustans to provide employment for Blacks. Israel even fails to do this for Palestinians. And even just last month, I heard him speak at an event from the PLO mission in The Hague during the Assembly of State Parties for the International Criminal Court, where again, he repeated the claim that he thought Israel was worse than apartheid South Africa. The second person is Richard Falk, who succeeded Dugard as rapporteur. And he also has been writing on the conflict for more than 50 years. And you're probably familiar with him for his promotion of the 9/11 conspiracy theories, anti-Semitic cartoons, and endorsing anti-Semitic books. And during his tenure as rapporteur, he also endorsed the Russell Tribunal. In 2011, he published an op-ed in Al Jazeera saying that it was his belief that Israel is committing the crime of apartheid. He, in his 2014 report to the council, he reiterated that claim. And then in 2017, he co-authored a report along with a woman named Virginia Tilley, who was the editor of the 2009 HSRC report for the UN Economic and Social Commission for Western Asia, again, branding Israel guilty of the crime of apartheid. And this report was deemed so controversial that within a few days of publication, UN Secretary General Guterres formally withdrew it. But they went on to issue a follow-up report in 2019 where they speak about how the structure of apartheid the analysis should make sure that it applies to the Palestinian people as a whole and not just focus on territories. It claimed that the Oslo process was just a, quote, Zionist game plan, and concluded, quote, that a political compromise at this stage can only be achieved by a single unified Palestine with equal rights for all. And the paper called on civil society to adopt an apartheid discourse and paradigm. So enter in civil society to 2021, what we have seen. Many of the NGOs that are engaging in the charge now are, and I have to put on my NGO Monitor hat, have received significant funding from the EU, European governments, and church-based development agencies, and NGO Monitor is going to be issuing a detailed report on this topic in a few weeks. But now they've also invoked the Jewish supremacy tropes, the river to the sea discourse, which is a notable development. And also there's been a lot of prominence given to academics who are reviving these tropes. For instance, Nora Erakat, who I mentioned earlier, on a symposium on apartheid that actually Josh contributed to on the European Journal of International Law blog, wrote a post invoking Sayegh again, where she wrote that Zionist belief that Jews constitute a race and a singular people, irrespective of religious piety or identification, produces three corollaries: racial self-segregation, racial exclusiveness, and racial supremacy. So to conclude my remarks, the new threshold crossed is that longstanding anti-Semitic tropes and propaganda have now been explicitly adopted by human rights NGOs and international institutions like the UN in order to challenge the legitimacy of Israel itself. And with that, I will turn it over to Josh. Thanks.
Thanks, Anne, and thank you, Gunther and Alvin too, for your introductory remarks. Just to add a little bit of color to the introduction from Alvin, I'm a barrister based in London. I have a background in international criminal litigation at the international criminal tribunals. On the defense side, I've been a member of defense teams at the Khmer Rouge tribunal in Cambodia, where I was defending Ieng Sary, who was the foreign minister of the Khmer Rouge government there. I was a member of the defense team for Jadranko Prlić at the ICTY. Prlić was the prime minister of the Bosnian Croat entity established in Bosnia-Herzegovina during the conflict there between 1993 and 1995, and a member of the Uhuru Kenyatta defense team at the ICC, and Uhuru Kenyatta is now the president of Kenya. So I'm going to make some brief general comments on the legal elements of apartheid as an interstate prohibition and as an international crime, which are relevant to how the analysis has been framed by various NGOs over the past 12 months. And I'm then going to focus on the factual element of domination and the mental element of an intention to maintain a regime of domination, and how that's been framed in the Israeli-Palestinian context, and how its meaning or meanings have been tailored to fit the facts of the case. And to illustrate that, I'll finally focus on Israel's law of return and how that legislation has been argued to be reflective of a regime of Israeli domination for the purposes of proving apartheid as a crime against humanity and as a violation of the interstate prohibition of apartheid. So that alludes to my first general point, which is there is no singular definition of apartheid or even a single characterization of apartheid, because as I've alluded to, apartheid exists in two, or perhaps more accurately, three forms. The first is at the interstate level, as I've suggested. Under general international law, irrespective of any treaty relationships, a norm has crystallized that has widespread state support, including that of the State of Israel, which prohibits the practice of apartheid by states and as between states. And that's reflected by the near universal ratification of the International Covenant for the Elimination of All Forms of Racial Discrimination, which contains a specific and express prohibition of apartheid binding on states in its Article 3, but doesn't offer any definition of that prohibition under that specific instrument. And it's right to say, I would suggest that instrument has crystallized into a norm of customary international law. So even a state which has not signed or has ratified that instrument would nevertheless be bound by the prohibition of apartheid that it contains. The second form of prohibition is a criminal offense, which is distinguished from the interstate prohibition because as a criminal offense, it's binding on individuals rather than obliging or prohibiting states from undertaking specific conduct. And there, the crime of apartheid binding on individuals, natural persons, is contained in treaties, which it's right to say have not gathered the same level of widespread support as the International Covenant for the Elimination of All Forms of Racial Discrimination. And those treaties are firstly the Apartheid Convention of 1973, which has been ratified by 109 states. And secondly, 1998's Rome Statute, which established the International Criminal Court, which has been ratified or acceded to by 126 states, or depending on how you categorize certain states, such as the Cook Islands, or arguably the state of Palestine, which have not met the threshold for statehood generally understood objectively under international law. But nevertheless, those states or US non-member observer states, more accurately, and member states have accepted as a binding norm that apartheid is criminalized as a crime against humanity by the ICC statute. I said thirdly, or there are three sources of law here, and it's right to say too that the first additional protocol of 1977 to the Geneva Conventions also criminalizes apartheid as a so-called grave breach, in other words, as a war crime. Israel, for its part, has ratified none of these treaties, and there is a very real question as to whether apartheid exists as a crime against humanity under general international law at all, or as a war crime, for that matter, under general international law at all. And that means it is arguable whether the crime is binding on individuals under international law when or if it is committed by states or by nationals of states which have not ratified the treaties under which it is criminalized. It also means that there's no single definition of the crime under international law or general international law. There are definitions of apartheid under the Apartheid Convention and the Rome Statute, but not under Additional Protocol 1, nor under the International Covenant for the Elimination of All Forms of Racial Discrimination. So when we talk in this conversation, as we will do, about the definition of apartheid or its elements, we're really talking about the definition of elements of crimes under treaties which Israel has not consented to be bound by at all. And that's not the end of the story, because in February last year, a majority, i.e. 2 out of 3 judges of a pretrial chamber at the International Criminal Court ruled that the ICC is permitted to exercise its jurisdiction, including over the crime of apartheid, as it's defined in the Rome Statute, over what it construed as the territory of the state of Palestine, which it defined by a majority again as comprising the West Bank, Gaza, and East Jerusalem. Now, time doesn't permit me today, nor does the scope of this discussion, to go into the merits and demerits of that decision. But it is relevant for our purposes as it operates to provide the basis for an argument that the Rome Statute's definition of apartheid is binding on individuals, including Israelis, in the West Bank, Gaza, and East Jerusalem, even if, which can be assured, that purported basis is wholly rejected by Israel. And for that reason, in the remarks which follow, I am going to focus on the definition of the elements of apartheid as a crime against humanity under the Rome Statute. And that definition is contained in Article 728 of the Rome Statute. If you want to Google it and have it in front of you, you might find that helpful, but I'll read it just in case you don't have access to the Rome Statute easily available in front of you. So apartheid is defined as inhumane acts of a character similar to those referred to in paragraph 1. And so those acts referred to in paragraph 1 are other enumerated crimes against humanity of murder, extermination, enslavement, deportation, forcible transfer, forced pregnancy, enforced prostitution, sexual slavery, and persecution and enforced disappearance and other forms of sexual violence of comparable gravity. So there's a high gravity threshold to establish an inhuman act, and that may form the subject of discussion and questions later. But I'm going to move on to the core of the definition, which is apartheid is inhuman acts committed in the context of an institutionalized regime of systematic oppression and domination by one racial group over any other racial group or groups, and committed with the intention of maintaining that regime. So we see there the elements of systematic oppression and domination as a matter of fact, an institutionalized regime as a matter of fact, one racial group over another racial group as matters of fact, and a mental element of intention of maintaining that regime of systematic oppression and domination. And to prove the crime against humanity, or a crime against humanity, the prosecutor must also establish that the crime was committed as part of a widespread or systematic attack directed against a civilian population with knowledge of the attack. And that flows from the position that the reason that crimes against humanity so shock the conscience of mankind and warrant intervention by the international community is because they're not isolated random acts. They rather result from a deliberate attempt to target a civilian population by way of a state or an organizational policy. So turning to the element of domination specifically, because I don't have time, unfortunately, to go through all of those elements. So I'm going to just drill down into one element and one element of proof that is being suggested to apply to that element in the Israeli-Palestinian context. But in undertaking a complete analysis of the problem, one needs to go through each element and then each element of proof. And that was what Anne was alluding to before well, it's actually in the discussion we were having before the webinar began, that when Human Rights Watch or the charges being made against Israel in reports, which are 250 pages long, it's a lengthy and complex exercise to go through each of the suggested elements of proof of each of these elements of the crime. So we're just going to focus on one in this for this purpose. So under the Rome Statute, you'll recall that that domination by one racial group over another racial group and an intention to maintain a regime of domination are mental and factual elements of the crime. And in its report on the situation in Israel, Human Rights Watch argue that the element of domination lacks a clear definition but appears in context to refer to an intent by one group to maintain heightened control over another, which can include control over key levers of political power, land, and resources. So Human Rights Watch identify the element of domination as equating to a concept of control. Yet John Dugard, when co-authoring with another author by the name of John Reynolds, analyzed the problem in 2013, they argued that the essence of the definition of apartheid is a systematic, institutionalized, and oppressive character of the discrimination involved and the purpose of domination that is entailed. And we'd suggest that an emphasis on the purpose of domination suggests that any legal assessment of the element extends beyond a question of mere factual control and encompasses apartheid's essence as a form of racial discrimination, and in particular, an aggravated form of racial discrimination. And in other words, for Dugard and Reynolds, if not Human Rights Watch, the exercise of control must relate to an intent to maintain racial superiority. So in our work, Anne and I argue that this apparent inconsistency between Human Rights Watch and Dugard and Reynolds can be resolved in a precise way. And that's because the Apartheid Convention makes a clear reference that apartheid shall include similar policies and practices of racial segregation and discrimination as practiced in Southern Africa. And it follows, we argue, that there's a legal basis to consider the policies and practices of Southern Africa when seeking to establish the elements of the crime of apartheid. And such an approach, such a methodology informs our understanding of domination as an element of the crime. And in particular, we argue that the concept of domination can be understood through Southern African practices of racial supremacy, so-called baskap in Afrikaans, and segregation. And we argue that that concept of domination as supremacy is central to a conception of apartheid as practiced in Southern Africa, and it therefore informs the definition of domination as an element of the crime of apartheid under the Rome Statute, and a focus or construing the element of domination as a form of control has no legal basis whatsoever. And in fact, we would suggest that by zeroing in on domination and equating it with an element of control, one is looking to tailor the facts of the Israeli military administration in the West Bank and Israel's nature as a Jewish state in the state of Israel proper to the element as defined as control in this instance, because it's easy to establish Israeli factual control over parts of the West Bank, over the state of Israel, and it enables the self-fulfilling result which is desired. We argue, on the other hand, that looking at the element of domination through the prism of racial supremacy, the existence of a Jewish state does not reflect such a regime. And to disparage the concept of a Jewish state by claiming that it contradicts the principle of equality at all denies the principle of two states for two peoples. Whilst one of those peoples defines itself and therefore is Arab and Palestinian, the other defines itself and therefore is Jewish and Israeli. And in the West Bank, separate systems of law were prescribed for by the Oslo agreements, agreed to by the Palestinian Liberation Organization, and those agreements were witnessed and guaranteed by representatives of the international community. And those same legal arrangements are intended to safeguard and protect the rights of both Palestinians and Jews in the West Bank, not to enshrine a regime of racial supremacy. So we argue that notwithstanding very real concerns regarding the existence of institutional discrimination in Area C of the West Bank, those concerns, we argue, do not reflect an institutionalized regime of racial supremacy. The discrimination practiced against Jews and Israelis in Area A of the West Bank is arguably another matter, but that's not, again, not the focus of our discussion today. What I am going to go towards is some brief remarks on Israel's law of return, because Human Rights Watch argue that the law denies Palestinian refugees and their descendants the ability to enter and live in areas where they or their families once lived and have maintained links to, and thereby creates a discriminatory reality. They accept that international human rights law gives broad latitude to governments in setting their immigration policies, and they accept that there's nothing in international law that bars Israel from promoting Jewish immigration. Yet Human Rights Watch claim that that latitude does not give a state the prerogative to discriminate against people who already live in that country. And we'll just focus on that for a moment, including with respect to rights concerning family reunification and against people who have a right to return to the country. Palestinians are also entitled to protection of their safety and fundamental rights, say Human Rights Watch. So accordingly, the law of return is cited as evidence of Israeli domination as a matter of fact, and Jewish Israeli intent to dominate Arab Palestinians as a mental element. Yet the argument that the law of return provides evidence of Israeli domination over Palestinians is contingent on there being a Palestinian legal right that is unlawfully denied. That is a contested legal fact, but a reader would not be led to believe that from the literature concerning Israel, as it's not disclosed by Human Rights Watch in its work, nor by any of the other authors alleging Israeli responsibility for the crime of apartheid. But it's right to say that Israel's law of return, for its part, does not discriminate between different categories of citizens within the country. It doesn't make the citizenship of non-Jews of Israel in Israel inferior. Rather, it's directed outward to the Jews of the world. Those who condemn the law of return hold that Israel has no right to treat foreign citizens who are Jews preferentially in its laws on immigration and naturalization. Yet a sovereign state has wide latitude as regards its policies on immigration and naturalization, and this is a principle which is specifically enshrined in Article 1.3 of the CERD, of the International Covenant for the Elimination of All Forms of Racial Discrimination, which states that nothing in this convention may be interpreted as affecting in any way the legal provisions of states parties concerning nationality, citizenship, or naturalization, provided that such provisions do not discriminate against any particular nationality. It's been argued that the law of return's purpose is to rectify historic wrongs committed against the Jewish people who lived as a minority throughout the world, as this audience will be well aware, and as such were persecuted, deported, destroyed, and unable to achieve national independence. These considerations of corrective justice, it said, might create a justified exception to the principle of equality, as well as falling within the exception created by Article 1.3 of the CERD. And similarly, it's in such policy or legislation would be by no means unique or unusual. In Europe, it's accepted that in some areas, including in relation to immigration and naturalization, a state is permitted to maintain official ties with kin outside its borders and to treat them preferentially. For instance, in the 1950s, Germany expanded the right to automatic citizenship to all ethnic Germans from the Soviet Union or Eastern Europe. In 1996, Finland amended its foreigners law to confer residency status on ethnic Finns who came to Finland from the USSR. There's also a distinction between ethnicity, national identity, and citizenship in the constitutions of Poland, Ireland, Armenia. In Asia, China has maintained institutionalized connections with its diaspora for decades. South Korea does likewise. Turkey maintains a strict version of civic nationalism based on a full congruence of citizenship and national identity. So neither the law of return nor the interest of the State of Israel in preserving Jewish ethnic or national identity can be construed as unique, irrational, or still less domination or reflecting racial supremacy. On the contrary, these goals are consistent with international norms, which include the principle of equality. I think we have almost used our time, Gunther. So because we have almost used our time, I'll thank you all and look forward to some questions in the chat.
Very good.